Hi, I'm Claire, and today I'll be briefly explaining the unjustified threats provision under the Patents Act. IP litigation generally is known to be extraordinarily expensive and often out of reach of litigants. It's tempting for a patentee to threaten alleged infringers with legal action in an effort to ward off expensive and time-consuming litigation. However, a patentee should be cautious when exercising the right to legal action over a granted patent, as threatening a perceived infringer with legal action may result in the alleged infringer claiming an unjustified threat. In this scenario, Ben has been granted a patent and becomes aware that Frank is infringing on his rights. He corresponds to Frank on his alleged patent infringement. As an aggrieved person, Frank may seek relief from Ben's unjustified threats of infringement proceedings under Section 128 of the Patents Act. Frank can seek relief from unjustified threats in several ways: a declaration that the threats are unjustifiable, an injunction against the continuance of the threats, and the recovery of any damages sustained as a result of the threats. Now, we'll briefly explore the elements of unjustified threats provisions listed here. Element 1. Delivery. This element contemplates circumstances which a patent holder seeks to inhibit competitors by making vague threats by means of circulars, advertisements, or otherwise, as well as by more conventional means, such as letters. This element has been interpreted broadly, capturing almost any means to deliver a prospective threat, including threats made orally, in writing, by means of advertisements in newspapers, trade journals, or included as a circular with packaging of the product. In order to be actionable, the communication must specifically constitute a threat of infringement proceedings. The question then becomes, what constitutes a threat? For patent cases in Australia, the most commonly accepted test for determining whether the communication constitutes a threat is whether the language would convey any reasonable person that the author intended to bring proceedings for infringement. The second question then is, when is a threat unjustified? We'll explore this by using the case of Mizzy and then DSI. Mizzy was the owner of a patent for a cane billet planter, a planting apparatus for sugarcane. Mizzy initiated proceedings against Morellini for infringement of the patent. Morellini counterclaimed that the patent was invalid and for unjustifiable threats. The basis for Morellini's unjustified threat was a vague threat which appeared in the Cane Growers magazine, where Mizzy had placed an advertisement including a patent application next to an article entitled Infringement Danger. The author of the article had worked with Mizzy on his patent application. Morellini's counterclaim for patent invalidity was unsuccessful, as the court found Mizzy's patent to be valid. The court also held that Morellini had not infringed on Mizzy's valid patent. However, although the threats were not directed at Morellini, the court found the advertisement and patent application alongside the article was an unjustifiable threat. The case of DSI contemplated a threat by Garford to sue DSI for patent infringement of a patent for rock bolts held by DSI. As the court held that DSI's patent claims were not valid, there could be no infringement and therefore considered the threat by DSI to Garford unjustified. So the question then is, when is the threat justified? Well, per Section 129 and the case of Enemy Bowder, threats of infringement proceedings are considered justified where the claims in question are valid in the eyes of the court and are actually infringed. Thanks for watching.